I knew something was wrong the moment I pulled into my driveway and saw the massive green storage shed blocking the utility easement that ran along the back of my property. It was Tuesday afternoon in late March, and I had just returned from a week-long business trip to Portland. The shed hadn't been there when I left, and now it sat there like some kind of monument to stupidity, painted in what I could only describe as a shade of green that assault victims might use to describe their attacker. My name is Connor Garrett, and I had been living in the Meadowbrook Heights subdivision in Gilbert, Arizona, for about 3 years. It was one of those newer developments with strict HOA rules, manicured lawns, and neighbors who would report you if your trash can stayed out 15 minutes past collection time. I had always followed the rules, paid my dues on time, and kept my property in pristine condition. But this was something else entirely. I parked my car and walked around to the back of my property to get a better look. The shed was enormous, maybe 20 feet long and 12 feet wide, sitting directly on top of the clearly marked utility easement. I had the survey from when I bought the house, and I knew exactly where the easement was. It was documented in my property deed. The electric company had access rights to that 10-foot wide strip of land that ran behind several properties on my street, including mine. Before I could even process what I was looking at, my doorbell rang. I walked back around to the front and opened the door to find Patricia Brennan, the HOA president, standing there with her clipboard and that expression she always wore, the one that suggested she had just smelled something unpleasant but was too polite to mention it. "Mr. Garrett," she said, not quite meeting my eyes, "I wanted to inform you that the HOA has installed a community storage facility on the easement behind your property. We will be storing maintenance equipment, holiday decorations, and other community items there. I trust you have no objections." I stared at her for a moment, trying to determine if she was serious. "Patricia, that's a utility easement. You can't build on a utility easement. It's literally in the property documents. The electric company has access rights." She waved her hand dismissively, the gesture of someone who had already decided they were right and any contradicting information was merely an inconvenience. We checked with our HOA attorney, and he assured us that since the HOA owns the common areas and has authority over community improvements, we can utilize any available space. The easement hasn't been used in years. It's just wasted space. "That doesn't matter," I said, feeling my blood pressure rising. "An easement is a legal right. Just because it's not being actively used doesn't mean it can be built on. When the electric company needs access to their lines, and they will eventually need access, they're going to tear that shed down." Patricia pursed her lips. "I'm afraid you're mistaken. The matter has been decided. The shed will remain. Now, if you'll excuse me, I have other homeowners to notify." She turned and walked away before I could respond, her sensible beige heels clicking on my sidewalk. I spent the rest of that evening researching utility easements and HOA authority. Everything I found confirmed what I already knew. The HOA had absolutely no right to build a permanent structure on a utility easement. The easement gave the electric company the right to access, maintain, and if necessary, remove any obstacles to their infrastructure. I pulled out my property documents and found the exact language. The easement was recorded with the county and ran with the land. It was non-negotiable. The next morning, I called the electric company. After navigating through their phone system for what felt like an eternity, I finally reached someone in their right-of-way department. Her name was Sandra, and she sounded tired. "Let me get this straight," Sandra said after I explained the situation. "Your HOA built a storage shed on our easement without contacting us. That's exactly what happened. It went up sometime in the last week. It's a pretty substantial structure. I heard typing on the other end. Okay, I'm looking at our records now. We have a 10-foot easement running behind properties on Sagaro Drive, which includes your address. That easement is clearly marked in our system. Nobody contacted us about any construction. What happens now? I asked. Well, I need to send someone out to assess the situation. If there's an unauthorized structure on our easement, we'll send a notice to whoever built it. They'll have a certain amount of time to remove it. If they don't, we'll remove it ourselves and charge them for the cost. How long does that usually take? Sandra sighed. In normal circumstances, we give 30 days notice. But if we determine that the structure poses an immediate risk to our ability to access our infrastructure, we can act more quickly. Let me get an inspector out there by the end of the week. I thanked her and hung up, feeling slightly better. At least something was happening. 2 days later, I was working from home when I saw a white truck with the electric company logo pull up outside. A man in a hard hat and safety vest got out, consulted a tablet, and then walked around to the back of my property. I went outside to meet him. "Are you the homeowner?" he asked. "Yes, Connor Garrett. I'm the one who called about the shed." He nodded and pulled out some kind of measuring device. "I'm Ray, with the right-of-way department. This is pretty straightforward. That shed is completely on our easement. It's also sitting right on top of an access point we use for underground line maintenance. This is actually a serious problem." "What kind of problem?" Ray pointed to a metal marker partially hidden by the shed's foundation. "See that? That's a marker for our underground vault. We have junction boxes down there that we need to access regularly. With this shed here, we can't get to it. If we have an emergency, we'd have to tear through this structure to reach our equipment. That's not just an inconvenience, it's a safety issue." "So what happens now?" "I'm going to file an emergency removal order. Normally we give 30 days, but when there's a safety concern and our access is completely blocked, we can expedite. I'd say the HOA has about 7 days to remove this themselves, or we'll do it for them and bill them. And I can tell you right now, our removal costs are going to be significantly higher than if they just hired someone to take it down properly." Ray took photos from every angle, made notes on his tablet, and then handed me a card. "If you have any questions, you can call me directly. We'll send certified letters to whoever owns this structure." "Do you know who that would be?" "The HOA. Meadowbrook Heights Homeowners Association. The president is Patricia Brennan." He wrote that down. "Got it. They'll be hearing from us very soon." True to his word, 3 days later I saw Patricia storming down the street toward my house. It was early Saturday morning, and I was drinking coffee on my front porch, enjoying the relatively cool Arizona spring weather before it turned into an oven. "This is your fault," she shouted before she even reached my driveway. "You called the electric company. Do you have any idea how much trouble you've caused?" I set down my coffee cup carefully. "Patricia, I didn't cause any trouble. You built an illegal structure on a utility easement. I simply informed the electric company of the situation. We received a letter saying we have 7 days to remove the shed, or they'll do it themselves and charge us over $20,000. $20,000. Do you know how that's going to impact our HOA budget?" "Then I suggest you remove it," I said calmly. "You shouldn't have built it there in the first place." Her face was turning an alarming shade of red. "We have a right to use common areas for community benefit. This is harassment. I'm going to file a complaint against you for interfering with HOA business." "Go ahead," I said. "File whatever you want. But that shed is coming down one way or another. The electric company has legal rights that supersede HOA authority. This isn't a difficult concept." Patricia jabbed her finger at me. You're going to regret this. The board is meeting on Monday and we're going to discuss sanctions against you for this stunt. You'll be fined for every violation we can find. We'll make your life miserable. That sounds like retaliation, Patricia. I'd be careful about that. I've already documented everything, including this conversation. She opened her mouth to say something else, then seemed to think better of it. Instead, she turned and marched away, pulling out her phone and jabbing at it aggressively. Monday came and went. I didn't hear anything from the HOA, but I did notice that the shed was still there. The 7-day deadline was approaching, and it seemed like the HOA had decided to call the electric company's bluff. That turned out to be a massive mistake. On day 8, I was again working from home when I heard the rumble of heavy equipment. I looked outside and saw 2 large trucks, several workers in safety gear, and what appeared to be a small crane. Ray, the inspector I had met, was directing operations. I went outside, careful to stay out of their way. "You're taking it down," Ray looked up from his clipboard. "Yep, they didn't remove it, so we're doing it for them. And since they ignored the notice, they get charged our full emergency removal rate, plus we're adding a penalty fee for non-compliance. The original estimate was about $20,000. Now they're looking at closer to 40. I watched as the crew worked with impressive efficiency. They used power tools to disassemble the shed, carefully separating materials that could be recycled from those that couldn't. The whole operation took about 4 hours. By early afternoon, there was nothing left but some disturbed ground and a pile of sorted materials waiting to be hauled away. One of the workers was using a ground compactor to smooth out the area when Patricia showed up again, this time with 2 other people I recognized from the HOA board. One was Margaret Foster, the vice president, and the other was Keith Wu, the treasurer. "Stop! Stop right now!" Patricia was practically screaming. "You can't do this. We're filing an injunction." Ray walked over to her calmly. "Madam, we can do this and we are doing this. You were given proper notice. You had 7 days to remove the structure yourself. You didn't. Now we're removing it and you're going to be billed for the service. We never agreed to this. This is our property." Ray shook his head. "No, madam, it's not. This is a utility easement. You don't own it, you don't have rights to it, and you definitely can't build on it. If you have complaints, you can take them up with our legal department. The contact information was in the notice you received." Keith, the treasurer, looked like he might be sick. $40,000. We don't have $40,000 in the budget for this." "Then you're going to need to figure that out," Ray said. "The bill will be sent to the registered owner of the structure, which according to our records is the Meadowbrook Heights HOA. Payment is due within 30 days. If you don't pay, we'll place a lien on the HOA's assets." Patricia turned to me and the look in her eyes was pure venom. "This is all because of you. You're going to pay for this. Actually, Patricia, you're going to pay for it. $40,000 apparently. I tried to warn you, but you didn't want to listen." The next few days were relatively quiet. I kept expecting some kind of retaliation from the HOA, but nothing came. Then, exactly 1 week after the shed removal, I received a certified letter. It was from the HOA's attorney, a man named Douglas Chapman. The letter was 3 pages of legal jargon that basically boiled down to this: I was being fined $15,000 for interference with HOA operations and causing financial harm to the community. I read the letter twice, then called my own attorney. His name was Michael Torres, and I had used him when I bought my house. He was good, thorough, and he didn't tolerate nonsense. "They're fining you for what?" Michael said after I read him the letter. "For calling the electric company about their illegal structure. They're claiming I caused them financial harm." "That's absurd. You can't be penalized for reporting illegal activity. And even if you could, HOA fines have to be for actual violations of the CC and Articles, the covenants, conditions, and restrictions. They can't just make up fines because they're angry at you. Send me a copy of that letter and your HOA documents. We're going to respond to this. I felt better after talking to Michael, but I also knew this was far from over. Patricia had made it clear she wanted revenge, and she wasn't the type to give up easily. The next HOA meeting was scheduled for the following Thursday. It was held in the community center, a small building near the neighborhood entrance. I normally didn't attend these meetings, but Michael had advised me to be there for this one. The meeting room was more crowded than usual. Word had apparently spread about the shed fiasco and the resulting fine against me. I recognized most of the people there, neighbors I'd waved to occasionally, but didn't really know. Patricia sat at the front table with Margaret and Keith, shuffling papers and studiously avoiding looking at me. When the meeting started, Patricia went through the usual administrative items, speaking in clipped tones. Then she got to what everyone was really there for. As many of you know, the HOA recently installed a storage facility to better manage community resources. Unfortunately, one of our residents decided to interfere with this project by filing a frivolous complaint with the electric company. This interference has cost the HOA $40,000, money that will now have to come from increased dues or reduced services. There were murmurs around the room. I raised my hand. Patricia looked at me like I was something she'd found on the bottom of her shoe. Yes, Mr. Garrett, I stood up. I'd like to clarify a few things. First, the complaint wasn't frivolous. The HOA built a structure on a utility easement, which is illegal. Second, I didn't cause the $40,000 cost. The HOA caused it by ignoring the electric company's notice to remove the structure. If you had removed it when they first asked, it would have cost a fraction of that amount. That's your opinion, Patricia snapped. The fact remains that your actions have harmed this community financially. An older man I didn't know stood up. Hold on. Are you saying you built something on a utility easement? I've been in construction for 30 years. You can't do that. That's basic property law. Patricia's face flushed. We consulted with our attorney. He assured us it was legal. Then your attorney is incompetent, the man said. Any first-year law student knows about easement rights. Who is your attorney? I don't see how that's relevant, Patricia said. Michael, my attorney, had been sitting in the back. He stood up now. I'm Michael Torres, and I'm representing Mr. Garrett in this matter. I'd like to address the fine that was levied against my client. HOA fines must be based on violations of the governing documents. Can you point to the specific provision in the CC and Articles that my client violated? Patricia consulted with Margaret for a moment, then said, He violated the Community Standards Clause by taking actions that harmed the community. Michael pulled out a document. I have a copy of the CC and Articles right here. The Community Standards Clause relates to property maintenance and appearance. It says nothing about reporting illegal activities or preventing the HOA from violating the law. Furthermore, Arizona Revised Statute Section 33-1242 specifically prohibits HOAs from retaliating against homeowners who report violations or exercise their legal rights. The fine you've levied against Mr. Garrett is not only unsupported by your governing documents, it's illegal retaliation under state law. The room was completely silent. Keith, the treasurer, leaned over and whispered something to Patricia. She shook her head firmly. The fine stands, Patricia said. If Mr. Garrett doesn't pay it, we'll place a lien on his property. Michael smiled, but it wasn't a friendly smile. If you do that, We'll file suit against the HOA for wrongful lien, retaliation, and harassment. We'll also be seeking attorney's fees, damages, and an injunction against the HOA. I strongly suggest you consult with competent legal counsel before proceeding." A woman in the front row raised her hand. "I have a question. Where is the $40,000 going to come from?" Keith said, "We don't have it in the budget." Keith looked miserable. "We're going to have to levy a special assessment. Each homeowner will be charged approximately $500 to cover the cost." That caused an uproar. People started shouting questions and complaints. Nobody wanted to pay $500 because the HOA board had made a stupid decision. "This is ridiculous," someone yelled. "Why should we pay for the board's mistake? You need to resign." Another person shouted at Patricia. Patricia banged her gavel, trying to restore order. "Everyone needs to calm down. This is Mr. Garrett's fault. If he hadn't called the electric company, we wouldn't be in this situation." The construction guy stood up again. "No, this is your fault. You built an illegal structure, you ignored the removal notice, and now you're trying to blame someone else for your incompetence. I'm calling for a vote of no confidence in the current board." Several people applauded. Patricia's face was now a deep crimson. "That's not how this works." "You can't just call for a vote." Michael stood up again. "Actually, according to your bylaws, any homeowner can petition for a special election with signatures from 20% of the residents. I'd be happy to help anyone who wants to pursue that." The meeting devolved into chaos after that. Patricia tried to maintain control, but it was clear she had lost the room. People were angry, not at me, but at the board for creating this mess. After about 20 more minutes of shouting and arguing, Patricia abruptly adjourned the meeting and stormed out. I left the community center feeling cautiously optimistic. It seemed like the rest of the neighborhood understood that the HOA board, not me, was responsible for the situation. But I also knew Patricia wasn't going to let this go. She had staked her reputation on being right, and admitting she was wrong wasn't in her nature. Over the next week, I heard through the neighborhood grapevine that a petition was indeed circulating to remove the current HOA board. I also heard that Patricia was telling anyone who would listen that I had orchestrated the whole thing to embarrass her. According to her version of events, I had known about the shed beforehand and had set a trap. Then things took a darker turn. I came home from work one day to find a violation notice on my door. According to the HOA, my lawn was not being maintained to community standards, and I was being fined $200. I looked at my lawn. It was perfectly maintained, exactly like it always was. I took photos from every angle, making sure to capture my lawn and my neighbor's lawns for comparison. There was absolutely nothing wrong with my grass. 2 days later, another violation notice. This time, I was being fined for having my trash cans visible from the street, even though it was trash day and everyone's cans were out. Another $200. The day after that, I was cited for having a vehicle parked in my driveway overnight. The vehicle in question was my own car, which I parked in my driveway every single night, just like most of my neighbors. It was blatant harassment, and I documented everything. Every notice, every photo, every detail. Michael advised me to pay nothing and keep records of everything. "They're building a case against you," Michael said. "Or rather, they think they are. What they're actually doing is building our case against them. This is textbook retaliation." Then I got a notice that the HOA was going to foreclose on my house for unpaid fines. The total amount they claimed I owed was $15,000 from the original fine, plus about $800 from the harassment violations, plus late fees and interest they had added. The notice said I had 30 days to pay, or they would place a lien on my property and begin foreclosure proceedings. That was when Michael filed suit. The lawsuit was comprehensive, naming the HOA, Patricia Brennan personally, and the other board members. We sued for harassment, retaliation, wrongful fines, abuse of power, and intentional infliction of emotional distress. We also filed for an emergency injunction to prevent the HOA from placing a lien on my property. The judge granted the emergency injunction immediately. The hearing for the preliminary injunction was scheduled for 2 weeks later, but in the meantime, the HOA was prohibited from taking any action against me. Patricia was furious. She left multiple voicemails on my phone, each one more unhinged than the last. In one, she accused me of trying to destroy the neighborhood. In another, she threatened to sue me personally for defamation. Michael advised me to keep the voicemails but not to respond. The preliminary injunction hearing was held in Maricopa County Superior Court. It was my first time in a courtroom for something like this, and I was nervous. But Michael was confident. The judge was a woman named Sandra Morrison, probably in her late 50s, with gray hair and sharp eyes that suggested she didn't suffer fools gladly. She listened to Michael's arguments, then turned to the HOA's attorney. Douglas Chapman, the attorney who had sent me the original fine letter, stood up. He looked uncomfortable. "Your Honor, the HOA has the right to enforce its governing documents and to fine residents who violate community standards." Judge Morrison looked at him over her reading glasses. "Mr. Chapman, I've reviewed the governing documents. Can you point to the specific provision that Mr. Garrett violated to justify the original $15,000 fine?" Chapman shuffled through his papers. "Your Honor, he interfered with HOA operations, causing significant financial harm." "That's not what I asked. I asked you to point to the specific provision in the CC and Articus that he violated. Does such a provision exist?" Chapman was silent for a moment. "The Community Standards Clause gives the HOA broad authority to maintain community welfare." "Mr. Chapman, I've read the Community Standards Clause. It relates to property maintenance, architectural modifications, and similar matters. It says nothing about prohibiting residents from contacting utility companies or reporting what they believe to be illegal activity. Do you have any legal authority that supports fining a resident for these actions?" "Your Honor, the HOA has discretion in enforcing standards." "That's not an answer to my question. Let me ask you something else. Are you aware of Arizona Revised Statutes Section 33-1242? "I am, Your Honor." "Then you're aware that it specifically prohibits HOA retaliation against homeowners who exercise their legal rights." "Correct." "Yes, Your Honor, but this isn't retaliation. This is legitimate enforcement of community standards." Judge Morrison pulled out a stack of papers. "I have here copies of violation notices issued to Mr. Garrett over the past 2 weeks. He was cited for lawn maintenance on a day when photographs show his lawn was identical to his neighbor's. He was cited for having trash cans visible on trash collection day. He was cited for parking his car in his own driveway overnight, which is apparently something he's done for 3 years without any previous violations. And all of these citations came after he filed a complaint about the original fine. Does that seem like legitimate enforcement to you, Mr. Chapman?" Chapman looked like he wished he could disappear. "Your Honor, I wasn't aware of all those details." "Perhaps you should have been. Perhaps you should have asked more questions before sending legal threats on behalf of your client. This appears to be a clear case of retaliation, and I'm frankly surprised that you, as an attorney, allowed it to proceed this far." She turned to her clerk. "The preliminary injunction is granted." The HOA is prohibited from assessing any fines against Mr. Garrett, issuing any violation notices, or taking any adverse action against his property pending the resolution of this case. Furthermore, all existing fines are suspended, and no liens may be placed. We'll set a trial date for 90 days from now. Michael thanked the judge, and we left the courtroom. As we walked out, I saw Patricia and the other board members standing in the hallway with Chapman. Patricia was gesturing angrily, clearly berating the attorney. He was shaking his head, looking defeated. "That went well," Michael said as we got to his car. "Judge Morrison clearly saw through their nonsense. Now we wait for them to come to their senses and settle." "You think they'll settle?" "Oh, they'll settle. Chapman knows they have no case, and after that hearing, he knows they're going to lose badly if this goes to trial. Plus, the HOA's insurance carrier is going to get involved soon, if they haven't already. Insurance companies don't like paying out on cases where their insured acted in bad faith." Michael was right. 3 weeks later, I received a settlement offer. The HOA would drop all fines against me, formally apologize, agree not to take any action against me for 5 years, and pay my attorney's fees, which had reached about $12,000. In exchange, I would drop my lawsuit. I wanted to take it to trial. I wanted to see Patricia held accountable, but Michael explained the reality. "You've won," he said. "You've proven your point, you're getting your attorney's fees paid, and you're getting protection from future harassment. If we go to trial, yes, we'll probably win, but it's going to cost you time, stress, and money. Even if we win damages, collecting from an HOA can be complicated. They don't have unlimited funds. Take the settlement." Reluctantly, I agreed. The settlement was finalized in early June, about 3 months after the shed had first appeared. I received a formal letter from the HOA board apologizing for any misunderstanding and confirming that all fines had been dropped. It was signed by Patricia, but I could practically feel her resentment through the paper. But the story didn't end there. The petition to remove the board had gained enough signatures, and a special election was scheduled for late June. I went to the meeting where the vote took place. The community center was packed. It seemed like almost every homeowner in the neighborhood was there. Patricia tried to defend her actions, arguing that she had been trying to serve the community and had been undermined by troublemakers. It didn't go over well. The vote was overwhelming. Patricia, Margaret, and Keith were all removed from the board. A new board was elected, including the construction guy, whose name I learned was Frank Davidson. The new board's first action was to hire a new attorney and to have a complete audit done of the HOA's finances. That audit revealed some troubling things. It turned out that Patricia had been using HOA funds somewhat freely. She had charged expensive dinners to the HOA, claiming they were business meetings. She had hired her nephew's landscaping company to do work around the neighborhood at rates well above market value. She had even taken a trip to a resort in Scottsdale for what she called an HOA conference, but no such conference had actually taken place. The total amount of questionable expenses was around $30,000. The new board contacted the police. I was at home one morning in late July when I saw the police cruiser pull up to Patricia's house. 2 officers got out and knocked on her door. About 10 minutes later, they left with Patricia in handcuffs. She saw me standing on my porch and screamed something I couldn't quite make out, but I'm sure it wasn't complimentary. Patricia was charged with theft, fraud, and embezzlement. The case made the local news, with reporters describing how an HOA president had misused community funds and then tried to cover it up by retaliating against a resident who had exposed other HOA wrongdoing. The trial took place in October. I was called as a witness to testify about the shed incident and the subsequent harassment. I explained everything that had happened, from finding the shed on my property to the fake violation notices to the attempted foreclosure. The prosecutor used my testimony to establish a pattern of behavior, showing that Patricia believed she was above the rules and could do whatever she wanted. The jury convicted her on all counts. The judge sentenced her to 2 years in prison, with the possibility of parole after 1 year, and ordered her to pay full restitution to the HOA. Margaret and Keith were not criminally charged, but they were named in a civil suit by the HOA to recover the money they had approved spending inappropriately. As for me, life in Meadowbrook Heights got a lot better after the new board took over. Frank Davidson turned out to be an excellent HOA president. He operated transparently, sent regular updates to residents, and made sure everything was done by the book. The first thing he did was lower the monthly HOA dues, since Patricia had been charging more than necessary to fund her lavish expenses. The electric company never rebuilt anything on the easement behind my property. They did come by every few months to check their underground equipment, accessing it through the spot where the shed used to be. Every time I saw them, I remembered Patricia's insistence that the easement was never used and therefore didn't matter. I ran into Douglas Chapman, the HOA's former attorney, at a coffee shop one morning in December. He looked tired. "Mr. Garrett," he said, nodding to me. "Mr. Chapman," I replied. There was an awkward silence. Then he said, "For what it's worth, I should have asked more questions." I represented the HOA, but that didn't mean I should have blindly followed Patricia's instructions. I should have seen what was happening. "You're right," I said. "You should have." "I don't represent HOAs anymore," he said. "I'm doing real estate transactions now, simpler, less drama. Less chance of ending up on the wrong side of a harassment lawsuit." "Probably a good call," I said. He nodded and left, looking like a man who had learned a hard lesson. The special assessment to pay for the shed removal was eventually charged to all homeowners, but the new board negotiated with the electric company to reduce the amount. They explained that the board which authorized the construction had been removed and was facing criminal charges. The electric company agreed to cut the bill in half, reducing it to $20,000. That meant each homeowner only had to pay about $250 instead of $500. It was still annoying to pay for someone else's mistake, but at least the new board had tried to minimize the damage. One interesting development came in January of the following year. I received a letter from a law firm I didn't recognize. It was from Margaret Foster, the former HOA vice president. She was suing Patricia for defamation, claiming that Patricia had told the police and the prosecutors that Margaret had been the one who suggested embezzling the HOA funds. According to the letter, this was completely false, and Margaret was seeking damages for harm to her reputation. I didn't follow that case closely, but I heard through the neighborhood that Margaret eventually settled with Patricia for a nominal amount. Patricia didn't have any money anyway, so there wasn't much to get. Keith Wu, the former treasurer, moved out of the neighborhood in February. I heard he got a new job in Texas and wanted a fresh start. I didn't blame him. Even though he hadn't been criminally charged, his association with Patricia had damaged his reputation. People remembered that he had signed off on all those questionable expenses. Frank Davidson called me one evening in March, almost exactly a year after the shed had first appeared. "Connor, I wanted to thank you," he said. "For what?" "For standing up to Patricia. If you hadn't called the electric company, if you hadn't fought back against the fines, who knows how long she would have kept doing what she was doing. You exposed the whole thing." I just didn't want a shed on my easement, I said. Frank laughed. Maybe so, but you did the neighborhood a favor. We've made a lot of changes since the new board took over. We've updated our governing documents to include better oversight and checks and balances. We've established term limits for board members. And we've made sure everyone knows they have the right to question the board's decisions without fear of retaliation. That's good to hear, I said. There's one more thing, Frank said. We've recovered most of the money Patricia stole. Between the restitution order and the civil suit, we've got about $25,000 back. The board voted to use some of it to reimburse you for the stress and hassle you went through. We know your attorney's fees were paid, but we want to give you an additional $5,000 as compensation for everything you dealt with. I was surprised. You don't have to do that. We want to, Frank said. You're a good neighbor and you did the right thing. Consider it a thank you from the community. I accepted the money, though I donated half of it to a legal aid organization that helps homeowners fight unfair HOA actions. It seemed appropriate. Patricia served 13 months in prison before being released on parole. I heard she moved to New Mexico to live with her sister. She was prohibited from serving on any HOA board as a condition of her parole, which I'm sure was a relief to HOA members everywhere. The shed incident became something of a legend in Gilbert. Other HOA boards in the area heard about it and started being more careful about understanding property rights and easements. The local newspaper did a follow-up article about HOA overreach, using the Meadowbrook Heights case as a cautionary tale. The electric company even updated their procedures, now proactively sending letters to HOAs whenever they became aware of any construction near easements. As for the utility easement behind my property, it remains clear and accessible, exactly as it should be. Sometimes I stand there and look at the ground where the shed used to be, thinking about how a simple decision to build something in the wrong place led to someone going to prison. It wasn't really about the shed, of course. The shed just exposed what Patricia had been doing all along. But it started with that structure, painted that awful shade of green, sitting where it had no right to be. I still live in Meadowbrook Heights. The neighborhood is better now, more cohesive with a board that actually serves the residents instead of trying to rule over them. We have neighborhood barbecues occasionally, and people actually talk to each other. It's what an HOA community should be. I learned a lot from the experience. I learned that standing up to bullies is important, even when they have official titles and authority. I learned that documentation is crucial, that taking photos and keeping records can make the difference between he said, she said, and having actual proof. I learned that there are good attorneys out there who will fight for what's right, and I learned that most people are reasonable when given the facts. I also learned that some people, like Patricia, can't admit when they're wrong. They double down, they retaliate, they make things worse for themselves rather than just acknowledging a mistake. It's a character flaw that can lead people down very dark paths. Michael Torres, my attorney, and I became friends after everything was settled. We get lunch occasionally, and he tells me stories about other cases he's handled. Apparently, HOA disputes are more common than I realized. There's something about giving people a little bit of power over their neighbors that brings out the worst in some individuals. One thing that still amazes me is how quickly everything escalated. From noticing a shed on my property to watching Patricia get arrested took only about 4 months. It's a reminder that actions have consequences, and sometimes those consequences come faster than you expect. The electric company never charged the HOA double as initially discussed. The final bill of $20,000, negotiated down from $40,000, was technically just under their normal rate once you accounted for everything. but in Patricia's mind, and in the minds of the people who supported her at first, it was my fault that the HOA had to pay anything at all. They couldn't see that the bill existed because the HOA had built something illegal and then refused to remove it. They needed someone to blame, and I was convenient. That's something else I learned. People don't always want to hear the truth, especially when the truth makes them look bad. It's easier to blame the messenger than to acknowledge that your leaders made terrible decisions. But justice prevailed in the end. The system worked, slowly and imperfectly, but it worked. Patricia faced consequences for her actions. The HOA was reformed, and I kept my property free from illegal structures. Sometimes I wonder what would have happened if I had just ignored the shed. If I had decided it wasn't worth the fight. Patricia would probably still be running the HOA, still spending money inappropriately, still bullying residents who questioned her. The shed would still be there, blocking access to critical infrastructure. And eventually, when the electric company needed to access their equipment in an emergency, it would have been a much bigger problem. So I'm glad I made that phone call. I'm glad I fought back against the fines. I'm glad I didn't back down when Patricia tried to intimidate me. It wasn't always easy, and there were times when I questioned whether it was worth the stress. But looking back, I know I did the right thing. The Meadowbrook Heights community is better for what happened. We have better governance, better financial oversight, and a culture where residents feel empowered to speak up about problems. The shed incident became a catalyst for positive change, even though it certainly didn't feel positive while it was happening. Frank Davidson served as HOA president for 2 years before stepping down, having accomplished what he set out to do. The person who replaced him was a retired accountant named Susan Miller, and she's been doing an excellent job. The board meetings are now recorded and posted online for anyone who can't attend in person. Financial statements are distributed quarterly with detailed explanations. Decisions that affect the community are put to a vote whenever possible. It's a different neighborhood now than it was when Patricia was in charge. It feels like an actual community rather than a fiefdom. People help each other out, they communicate, they work together to solve problems. That's what I thought I was buying into when I moved here, and it took a crisis to finally make it happen. I still get recognized occasionally around Gilbert. Someone will say, "Aren't you the guy with the HOA shed thing?" And I'll nod and confirm that yes, that was me. Most people are supportive, sharing their own HOA horror stories and thanking me for standing up to an abusive board. A few people think I should have just gone along to get along, that causing trouble wasn't worth it. I disagree with them, but I understand where they're coming from. Not everyone wants to fight. The settlement money I received, the part I didn't donate, went toward a nice vacation to Colorado. I figured I deserved it after everything that had happened. I spent a week hiking in Rocky Mountain National Park, breathing clean mountain air, and not thinking about HOAs, easements, or Patricia Brennan. It was exactly what I needed. When I got back from that trip, I found a letter in my mailbox. It was from Patricia's sister in New Mexico, forwarded through the HOA. The letter was brief and to the point. Patricia wanted me to know that she still believed she had done nothing wrong, that I had destroyed her life over a simple disagreement, and that she hoped I was happy. The letter was bitter and accusatory, lacking any self-awareness or accountability. I thought about responding, explaining once again that she had brought everything on herself, but I decided against it. There was no point. Patricia was never going to understand or accept responsibility. Some people are just built that way. Instead, I threw the letter away and moved on with my life. That was over 3 years ago now. Life in Meadowbrook Heights has been quiet and drama-free since then. My lawn stays green, my trash cans go out on trash day and come back in. My car sits in my driveway every night, and nobody bothers me about any of it. The utility easement behind my property remains clear, accessible, and shed-free. I never sought out the conflict with Patricia and the HOA. I just wanted a simple resolution to a simple problem. A structure had been built where it shouldn't have been, and it needed to be removed. But sometimes, simple problems reveal complex issues, and sometimes standing up for what's right means accepting that things are going to get messy before they get better. If I had to do it all over again, I wouldn't change anything. Well, maybe I would have documented even more thoroughly from the beginning, but other than that, I would follow the same path. The shed needed to go, Patricia needed to be stopped, and the community needed to be reformed. All of those things happened, and while it was stressful and difficult, it was ultimately worth it. The electric company still has their easement, clearly marked and accessible. My property is still mine, free from encroachment. And the Meadowbrook Heights HOA is now run by people who understand that their job is to serve the community, not to rule it. That's really what the whole thing was about, when you strip away all the drama and conflict. It was about understanding boundaries, both literal and figurative. The HOA crossed a boundary when they built on the easement. They crossed another boundary when they tried to punish me for doing the right thing. And Patricia crossed every ethical and legal boundary when she embezzled community funds and abused her power. Those boundaries exist for good reasons. Property lines, easements, laws, regulations, they're not just arbitrary rules meant to make life difficult. They're frameworks that allow us to live together peacefully, to know what's ours and what's not, to have recourse when someone violates our rights. Patricia didn't understand or respect those boundaries, and she paid the price. I hope that wherever Patricia is now, she's learned something from the experience. I hope she's reflected on her actions and understands why they were wrong. But honestly, based on that letter from her sister, I doubt it. Some people never learn. They go through their whole lives blaming others for their problems, never accepting that they're the architects of their own disasters. But that's not my problem anymore. My problem was a shed on my utility easement, and that problem was solved. Everything that came after was just the natural consequence of Patricia's decisions. I just happened to be there to witness it and document it. The neighborhood kids sometimes ride their bikes along the path where the shed used to be. They have no idea that anything was ever there, no idea about the drama that unfolded over that patch of ground. That's probably for the best. They just see a nice neighborhood with well-maintained properties and friendly people. That's exactly what it should be. And when the electric company needs to access their underground equipment, they can do so easily. They pull up, walk to the access point, do whatever maintenance they need to do, and leave. No obstacles, no problems, no drama. Just a utility company accessing an easement they have legal rights to, exactly as the system was designed to work. It's funny how something as mundane as a utility easement became the center of so much conflict. But that's life sometimes. The biggest battles are often fought over things that seem small from the outside. To Patricia, the shed was about asserting authority and using space efficiently. To me, it was about property rights and following the law. To the electric company, it was about maintaining access to critical infrastructure. We all had different perspectives on the same physical object, and those perspectives were incompatible. In the end, the law was clear. The easement rights superseded the HOA's desire for storage space. The structure was removed, justice was served, and life went on. It's a simple story, really, despite all the complications along the way. But it's a story worth telling, because HOA overreach is a real problem in America. There are thousands of communities just like Meadowbrook Heights, with boards that sometimes forget they're volunteers serving their neighbors, not monarchs ruling over subjects. When those boards cross the line, when they violate the law or abuse their power, someone needs to stand up and say no. This time that someone was me. I don't consider myself a hero or an activist. I'm just a guy who bought a house, followed the rules, and expected others to do the same. When the HOA didn't follow the rules, I held them accountable. That should be normal, not exceptional. But in too many communities, people are afraid to challenge the HOA, afraid of retaliation, afraid of being labeled as troublemakers. I was afraid too, but I did it anyway, and things worked out. So if there's a lesson in all this, it's that standing up to abuse of power is worth it, even when it's scary. Document everything, know your rights, get good legal help, and don't back down just because someone has a title and authority. The system isn't perfect, but it generally works if you're willing to use it. And if your HOA ever tries to build a storage shed on your utility easement, call the electric company. Trust me on that one.